Hi friends, I'm Suzette Titus, presently pursuing second year PGDM, Human Resources from Wellinger Institute of Management, Development and Research. In this presentation, I will be talking about a law related to sexual harassment at workplace and the institutional mechanism to prevent sexual harassment at workplace. Civil society claims that 70% of women have had some sexual harassment experience. Studies show that many women suffer from sexual harassment at workplace, and it mostly goes unnoticed and unreported due to fear, stigma, and lack of knowledge and awareness about the laws relating to sexual harassment at workplace. Sexual harassment at workplace is an extension of violence in daily life, and it is discriminatory and exploitative as it affects women's right to life and livelihood. In India, for the first time in 1997, a petition was filed in the Supreme Court to enforce the fundamental rights of working women after the brutal gang rape of Banbari Devi, a social worker from Rajasthan. As an outcome of the landmark judgment of the Vishaka and others versus the state of Rajasthan, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 for employers, institutions, organizations, internal complaints committees and local complaints committee was enacted by the Government of India. Criminal Law Amendment Act 2013 and ratification of Convention of Elimination of All Forms of Discrimination Against Women, CEDAW, on 9 July 1993 made mandatory for every employer to provide a mechanism to redress grievances pertaining to workplace sexual harassment and enforce the right to gender equality of working women, thus bringing several changes to the Indian Penal Code in relation to sexual offences of women. The Act is unique as it applies to the organized as well as the unorganized sectors. Now let us look at how the term sexual harassment has been defined or described in law. Sexual harassment is any unwelcome, unlawful, unwanted physical or verbal or non-verbal conduct of sexual nature which creates an uneasy, uncomfortable atmosphere. Any expressions communicated in word or deed of any kind, like making sexually suggestive remarks, serious or repeated offensive remarks, such as teasing related to a person's body or appearance, offensive comments, puns or jokes of sexual nature, inappropriate questions or suggestions or remarks about a person's sex life, displaying sexist or other offensive pictures, pornography, posters, MMS, SMS, WhatsApp or emails, intimidation, threats, blackmail around sexual favors, threats, intimidation or retaliation against an employee who speaks up about unwelcome behavior with sexual overtones, unwelcome social invitations with sexual overtones commonly understood as flirting, unwelcome sexual advances which may or may not be accompanied by promises or threats, explicit or implicit. Physical contact such as touching or pinching, caressing, kissing or fondling someone against her will could also be considered as assault. Invasion of personal space, getting too close for no reason, brushing against or cornering someone, persistently asking someone out, despised being turned down, stalking or following an individual, abuse of authority or power to threaten a person's job or undermine her performance against sexual favors, falsely accusing and undermining a person behind closed doors for sexual favors, and controlling a person's reputation by rumor mongering about her private life. For better understanding, let us look at some examples of workplace behaviors that may not constitute sexual harassment, like following up on work absences, requiring performance to job standards, the normal exercise of management rights, work-related stress, for example, meeting deadlines or quality standards, conditions of works, and constructive feedback about the work mistake and not the person. Generally, sexual harassment refers to two common forms of inappropriate behavior. Firstly, quid pro quo, which means literally this for that. This type includes, firstly, implied or explicit promise of preferential or detrimental treatment in employment, and secondly, implied or expressed threat about her present or future employment status. Now let us look at an example of this type of sexual harassment. Sujata is a bright young team leader working in a call center. She is known to be forthright, dedicated, hardworking, and she is a perfectionist. Sujata one night stays back late with her colleague Raj to complete some important work for her next day's presentation. Raj offers to buy Sujata dinner and later drop her home since it's been a long day. After dinner, Raj proposes to Sujata to spend the night out with him. Sujata refuses politely but firmly and goes home. The next evening, Raj repeats his request and on Sujata's refusal, threatens her that if she does not give in, he will tell everyone that she made a pass at him, thus engaging in a smear campaign against Sujata. Now let us look at the second form of inappropriate behavior, that is hostile work environment. This type includes creating a hostile, intimidating or an offensive work environment and humiliating treatment which is likely to affect a woman's health or safety. For example, Vijay, Jaya's supervisor, often tries to touch her on one pretext or the other. For example, he adjusts her dupatta while she is sewing at her workstation on the pretext of covering her back. Jaya is very uncomfortable with his behavior. The physical touching by her supervisor is very unwelcome and sexual in nature. And the gossip which is based on Vijay's behavior is very unwelcome and is creating a hostile work environment for Jaya. Now let us look at who is an aggrieved woman. An aggrieved woman is the victimized woman who is facing the sexual harassment in the workplace irrespective of her age. The Act has also defined the words employee and employer. The terms employee includes all women, whether engaged directly or through an agent, including a contractor, with or without the knowledge of the principal employer. They may be working for remuneration on a voluntary basis or otherwise. Their terms of employment can be express or implied. She could be a co-worker, a contract worker, a probationer, trainee, intern, apprentice, or even a domestic maid at your house. The term employer means the head of a department, organization, undertaking, establishment, enterprise, HOD of an institution, college, school, classes, head of an office, branch or unit of the government or local authority or such officer. A person or a household who employs or benefits from the employment of domestic workers like maids is also an employer. Even a contractual employer or agent is an employer. Now, for the purposes of the Act, the term workplace includes government organizations, including government companies, corporation and cooperative societies, private sector organizations, venture, society, trust, NGOs or service providers, etc., providing services which are commercial, vocational, educational, sports, professional, entertainment, industrial, health-related or financial activities, including production, supply, sale, distribution of services. Workplace also includes hospitals, nursing homes, sports, institutes, facilities, places visited by the employee, including while on travel, including transportation provided by the employer. These also come under the purview of workplace. A dwelling place or a house can also be a workplace. The Act defines the unorganized sector as any enterprise owned by an individual or self-employed workers engaged in the production of sale of goods or providing goods or services of any kind. It also includes any enterprise which employs less than 10 workers. It is very important to note that all women working or visiting workplaces are also included within the purview of this Act. Now let us look at the primary responsibilities of the employer. Every employer having more than 10 employees has a bounden duty and responsibility by law to protect all his female employees against any kind of sexual harassment at the workplace. He needs to provide a safe working environment for all the female employees. The penal consequences of sexual harassment at the workplace must always be officially displayed in a prominent place at the workplace. Every organization must organize awareness programs regularly sensitizing the new employees. The employer must provide facilities to the committees to conduct an inquiry. It is the duty of the employer to assist in securing attendance of the respondent and witnesses and provide assistance to the aggrieved woman. The employer must treat sexual harassment as a misconduct and initiate immediate action. The employer should also monitor the reports of the Internal Complaints Committee. Now let us look at the Constitution of Internal Complaints Committee. The Sexual Harassment at Workplace Act 2013 provides for a redressal mechanism which includes the Internal Complaints Committee and the Local Complaints Committee. It is mandatory in any organization with 10 or more workers to have an Internal Complaints Committee. The Internal Complaints Committee should consist of the senior-most woman of the organization as a presiding officer of the Internal Complaints Committee. At least 2 employees familiar with legal knowledge or social work or women's issues should be a part of the internal complaints committee. Also, a third-party representative from an NGO or an activist committed to the cause of women. The local complaints committee will receive complaints from women working in an organization having less than 10 workers, when the complaint is against the employer himself and from domestic workers. It is important to understand the procedure for filing a complaint before the committee. When a woman faces sexual harassment at the workplace, she can make a written complaint to the Internal Complaints Committee within 90 days from the date of the last incident. The Internal Committee can extend the period with reasons in writing exceeding not more than 3 months. The legal heir of the aggrieved can make a complaint on behalf of the aggrieved in case of physical or mental incapacity or death of the aggrieved. Internal committee has the same powers as a civil court for summoning and enforcing attendance of any person and examining him on oath. The Internal Complaints Committee can also call for the production of documents. When the complaint is pending inquiry, the aggrieved woman can make a written request to the internal committee or the local committee, as the case may be, to transfer the aggrieved woman or the respondent to any other workplace or grant leave to the aggrieved woman up to a period of 3 months, that is, in addition to the leave she would be entitled to otherwise, or grant such other relief to the aggrieved woman as may be required. After the internal committee has completed its inquiry, it should draw up its report along with recommendations. This report must be provided to the employer as well as the concerned parties within 10 days of the completion of the inquiry. The employer shall act upon the recommendations of the Internal Complaints Committee within 60 days in case the allegation is proved. An amount shall be deducted from the wages of the accused employer. Now let us see what can an employee or worker expect from this act. When it comes to redress for workplace sexual harassment, an employee or a worker has a right to expect a trained, skilled and a competent complaints committee, a time-bound process, assurance of non-retaliation, counseling or other enabling support where needed, and assistance if the complainant opts for criminal proceedings. Let us look at the rights of the complainant. A complainant needs an empathetic attitude from the complaints committee so that she can state her grievance in a fearless environment. The aggrieved woman should be provided with a copy of the statement along with all the evidence and the list of witnesses submitted by the respondent. Her identity should be kept confidential throughout the whole process. She should be supported in lodging an FIR in case she chooses to lodge criminal proceedings. In case of fear of intimidation from the respondent, her statement can be recorded in the absence of the respondent. The aggrieved woman has a right to appeal in case she is not satisfied with the recommendations or findings of the complaints committee. The respondent also has some rights. He needs a patient hearing to present his case in a non-biased manner. The respondent should also be provided with a copy of the statement along with all the evidence and a list of witnesses submitted by the complainant. The respondent's identity should also be kept confidential throughout the whole process. The respondent has a right to appeal in case he is not satisfied with the recommendations of the Complaints Committee. It is the primary duty of the Complaints Committee to create an enabling meeting environment, to use a body language that communicates complete attention to the parties, and to treat the complainant with respect. The Complaints Committee should discard predetermined ideas. The Complaints Committee should not get aggressive or insist on a graphic description of the sexual harassment. It is the duty of the Complaints Committee to conduct the proceedings in a fair, just and sensitive manner. It is mandatory for every employer to implement the provisions of the Sexual Harassment of Women at Workplace Act, and if he fails to do so, he is liable to pay a penalty of up to Rs 50,000 for non-compliance of the Act. The employer will be penalized if he fails to set up an internal committee. He will be penalized if he fails to take action on inquiry report, or if he fails to file an annual report. If he fails to punish all false malicious complaints and false evidence, a previously convicted employer will bear twice the punishment or cognizance by court. Non-compliance of this act can also lead to cancellation or withdrawal or non-renewal of license or cancellation of government registration required for carrying on business or activities. With improved access to education, millions of women are entering the workforce in India today. Most of the women suffer from sexual harassment at workplace on a daily basis. Many women are forced to leave their jobs due to sexual harassment at workplace, which results in loss to both the employees as well as the organization. Simply ignoring the behavior is ineffective, thus encouraging the offender. It is best to prevent sexual harassment right at the start. Legally, workplace sexual harassment can no longer be dismissed as some moral transgression. Workplaces in India today must rise to the requirement of promoting gender equality. Dear friends, I hope that you are enlightened and hope you will encourage the right to life and liberty and the security of women. I urge you to promote and spread awareness of the Sexual Harassment of Women at Workplace Act 2013 and involve strong commitment to the cause. Goodbye friends, thank you and God bless you.